So here we go again. Today's webinar is on the new probate forms and rules that we have going into effect in a few weeks. And we went through a big one in January, effective January 1st of this year. Because of some blips and things that weren't quite correct originally, we've got some amended forms, we've got some new rules, we've got clarifications on a few things. So we're going to take you through that. So first thing we're going to talk about is just the purposes of the purpose of the changes, the effective date, and then we're going to look at two specific areas of change: applications for certificates of appointment and the whole process for administration bonds, as well as some other changes. So here we go. So the first thing is that just the overall purpose of this is to make it easier for the applicants for certificate of appointment and for the court staff, in essence, to hopefully avoid errors, to give a heads up to the court staff as to, there's either something's missing or there's something unusual, or we need a judge to get involved. And so as you see, and I will share the forms with you and highlight the differences and things like that. But those are the overall purposes of the changes. So we've got July the 1st of 2022, any applications for certificates of appointment, any of the documents that you're filing, any of that, effective July 1st, 2022, we're going to need to use the new forms, and the new rules will be in place. So just wanted to hit a few highlights of the documents, and then we're going to go into them in more detail. Just a reminder to everybody that we do send you these slides if you registered for the webinar. So don't worry, you're going to get a copy of all of this. So the first thing that I'm glad that they addressed, and something that we talked about, was the fact that Ontario allows for virtual presence of witnesses for due execution. Other jurisdictions might not. And since a certificate of appointment, what we used to call probate, is an in rem judgment in essence, it applies all over the world in essence. And so it's important that other jurisdictions recognize that the will, even though it doesn't look like their will and that it's signed in counterpart, is still valid. So now the certificate of appointment confirms that to all third parties. We have new forms for the application for certificate of appointment, for the certificate itself, for the affidavit of execution and condition, for orders in estate proceedings like dispensing with bonds, et cetera, for applications for certificates like resealing and successor estate trustees, and small estate forms. We also have some new forms that deal with dispensing with bonds, not new forms, but changes to the forms that deal with dispensing with the bond and estate administration, tax, payment, and filing. So what we're going to do, I thought I'd hit the high points here and talk about the documents that are sort of most relevant to us, and then we'll go from there. So the first thing is the actual application for certificate of appointment of a state trustee. So you'll recall that as of January 1st, we went with really a new whole system of probate forms, reducing the different ones and kind of combining them. And that's what we did in 74A. It now governs certificates of appointment of a state trustee, whether it's with a will or without a will, et cetera. So we made some change. I say we, but I wasn't involved. There are some changes made. For one thing, there's clarification about the disclosure of marital status, because as we know, effective January 1st, separation has an impact on marriage, on intestacy rights, and on wills, interpretation of wills and bequests to separated spouses. So we've clarified that a little bit. They've also allowed for us to explain if there's a missing date on a testamentary document, on a codicil, for example. And then there's a big section on the applicant's entitlement to apply. So this deals with a bunch of housekeeping matters. For example, if you've got a will that improperly says you only become the estate trustee if you survive for 30 days, which we should never do, of course, but occasionally you have that. So now there's that, there's questions about that. If there are different reasons why different applicants are applying, there's a spot for that. More detail about why an applicant is not applying, and the whole idea of non-appointed estate trustees. So you've got, nobody named in the will that's alive or that's willing to apply. There's the options for getting a majority of the beneficiaries supporting your application to be the estate trustee, or you have to bring a motion to the court under Section 29 of the Estates Act. So sort of setting that out. And what I thought maybe I'll do, and bear with me for a moment here. So what I've got here, well, as I discuss it, maybe we'll just call this up. So this is the new form compared to the old form. So if it's in red, that is in the new form. So one of the, you can see these are just some pretty minor changes and clarifying certain things. It talks about the marital status at the date of death, and note that you can check more than one. So you could be married and separated, etc. They've just clarified that it's the deceased's residence at the time of death. That is what you're inserting. The dates of the will, of course, that makes sense. And here's that discussion about if the date is missing. Now, this is the whole section about spousal relationships. And, was there a separation, a breakdown of the marriage if they were married at the date of a death? They've also just moved some things around. So don't be too worried about the fact that we're crossing out these different paragraphs. You'll see that there was this discussion about, of course, marriage after January 1st, 2022, and those kinds of things. So again, pretty typical stuff from prior, but just clarifications here and there, and they put it in a different order. So just be aware of that. Then what we've got is form changes relating to the beneficiaries. So now it does require the relationship to the deceased for each beneficiary, which was not required before. And it also, when I talk about misnamed beneficiary, that's where the name in the will does not match the name that you're putting down in the application for certificate of appointment. And so you can explain that to the court as well. And I'll just pull that up and show you that section. So that's here. They've changed some of the wording to make it a little bit made more sense, et cetera. And then here's the idea that you have to state in the row beneath the name in the will and explain the reason for the difference. So that's something new as well. This whole section is, as I mentioned earlier, explains why an estate trustee is not applying, because they've died, they've renounced, they're mentally incapable, they're under 18, or there's not another, and you need some further explanations. And here's the 30-day period kind of thing. Showing that you can apply. So that's where we're at there. Then there's some clarifications on the declarations. As you know, in the form, there are a bunch of declarations that the applicant makes. One of which they have clarified, which makes sense, and we've probably wanted it for a long time, is it's a statement that the estate trustee understands that they have to produce an accounting, but not necessarily, they don't have to provide it to a person who gets a specific legacy or a specific bequest. It's really only the residuary beneficiaries that need the accounting. And it also sets out the grounds for why you're entitled to bring this application for a certificate of appointment. Either the person is an Ontario resident, or they have Ontario property, and that means both real estate or personal effects. personal property, and then some other reason why you're entitled to get a certificate of appointment. Then I'll just take you to two other new parts of the form, and they relate to bonding, which we're going to talk about in a second, and the payment of a state administration tax, and whether you're deferring it, you're paying it in full, undertaking. So we've gotten rid of, we used to have to, if we filed with an undertaking, we had to file an undertaking letter. That's no longer required. And I'll show that to you right now. I know this isn't the most stimulating of discussions, but hopefully you guys are following along and finding this of some use. So these are the new forms. And the first thing is dealing with the estate administration tax, and basically confirming that you're depositing the full amount, or that you're seeking an order to defer the payment. And as we have talked about before on a webinar, there is the ability, if you don't have funds, and there's a few requirements, but to file an application without paying the probate tax, the estate administration tax. And so this just highlights for the court, oh, I'm going to be doing that. So it doesn't get rid of the requirement to bring that get an order, but it does at least give them the heads up about that. And then the third one is the idea, and this is quite common, that you base it on an estimated value, and confirms, rather than giving them an undertaking separate letter, it just now says, I basically am giving this undertaking within this application. So that's cutting down on the work that needs to be done when you're doing it that way. The second new, and that's a new section, by the way, this part 9 to the application. The next section, part 10, deals with bonding, and I'm going to talk about that in a moment, but basically confirms whether a bond is necessary or not. So there's really actually three. They should have probably broken this down into 3 separate ones, but one is the deceit, you're on an intestacy, where a bond is always required. 2, you're an applicant, but you're not named in the will as the estate trustee. Or 3, you're named in the will, but you live outside of, I don't know what just happened there. You live outside of Canada or the Commonwealth. So that's when a bond is required. And so either, again, you have the options, either I'll post the bond now, or I don't need to post a bond because I'm seeking an order on consent to dispense with the bond, and I've got the consent of all of the beneficiaries, and they're all adults and capable. Okay, so those are the requirements there, and we've talked about this before on our webinar. So you can check this off, and again, it doesn't get rid of the need to get an order dispensing with the bond, but it gives a heads up to the court that this is what's happening on this. There is the exception for a bond for a surviving spouse, a trust company, and then there's the idea of if you do have minors, or you can't get the consent of everyone to dispense with the bond, you can always bring a motion under Section 37. And so again, that's a formal motion as opposed to just getting an order. And I'll talk about that in a moment. So those are, I'm just gonna go back here for a second. Those are the new parts to Form 74A. Just turning now to just a few more specifics in the bonding and estate administration tax matters. So again, as I highlighted, I don't want to go through it again, but you're giving a heads up to the court about how you're going to deal with bonds, whether one's necessary or that you're dispensing with it. And there are new rules that deal with the whole bonding issue and what has to, we've basically codified what has to be in the affidavit. And I'm going to show that to you in a moment. So the new forms and the new rules, specifically 7411, deals with this new sort of requirement in the rules itself to deal with certain matters when you're seeking the dispensing of a bond. So let me just actually, I'm going to call up, which I have here, the new rule. This is the new rule. Since we deal with bonds so frequently, I just wanted to spend a couple of minutes on this. And this is the new rule, 7411, subs 2 and 3. Or actually sub 3, sorry, 2 is already there, sub 3, and 4 and 5, et cetera, and 6. So this is, you can make a motion to dispense with the bond, and you can either do it on consent. As I said, if you've got all the beneficiaries and they are all of age, they're all 18 or older, and they're all capable, then you can get the consent of all of them. And and you can get a consent order, basically. And all you have to do in that case, as you can see in sub 6, is file a draft order. You don't need a whole motion record. Draft order, a consent from every person, and this affidavit. And this is an important codification of the requirements that you have to address in an affidavit dispensing with a bond. And so who's entitled to share, what are the debts, what's the value of the estate, all of these things. And so when it should be a pretty standard affidavit now, that the court can quickly look at and determine whether the order should be granted or not. And if the order is granted, of course, you don't need to post a bond. And if it's not, then either the amount of the bond is reduced, if that's what you were seeking, or you have to pay, or the court says you got to pay the entire amount or post the entire amount of the bond. So that's a whole new section, 74.11 sub 3, 4, 5, and 6. So that's basically what we've got now. If you don't fit into that rule, if you can't get the consent of all the beneficiaries, either they're refusing, or you've got a minor who's a beneficiary, or you've got a mentally incapable person who can't consent, then you need to bring a motion and get the court. It's not as simple as just a consent. You need a full motion, record, etc. So that's that. The new order for dispensing with a bond is part of the order governing estate matters, and basically they've just made it clear that now there's just a provision we should be using the same wording for all of our orders dispensing with a bond. So that's in that, and that's in the new form as well. So those are the issues I wanted to address on that front. What I did as well is I compared some of the this is the order in estate proceedings, which I was just mentioning, and so you're into this, you're trying to dispense with a bond, and this is the form that you use. It's form 74I, and it's been amended to include that this is the old form of the order when you're getting a dispensing of the bond, or the deferment of payment of estate administration tax. This is the certificate of appointment, and this also has been amended. And you can see they've cleaned some things up, obviously, that I'm not necessarily going to go into. Don't worry about Mike Rotman. Apparently, he must have been the person who worked on from the ministry on this document. So, but when I compare it, that's what I get. So, couple things. This includes confirmation that, of course, the will is attached to it. And this is the provision that I was mentioning that confirms to the third parties and the rest of the world that this was executed remotely and signed in counterpart pursuant to the Succession Law Reform Act. So don't be alarmed. Basically, it's saying don't be alarmed that you've got counterparts. We count that as valid. And then there's some specific provisions for what happens. The wording for precisely what happens if somebody's renounced or somebody is predeceased. This is an applicant, et cetera. So that's what the new form says. And I'm going to leave time for questions, but I think I have one more. And somebody has their mic on. If you don't mind just muting, that would be wonderful. The last document that I wanted to highlight before I address any questions, and you can feel free to put them in the chat, is the affidavit of execution. Now, this was something that I raised originally. They put in two clauses that made no sense. They duplicated 3 and 4. And so now they've deleted 3. We don't need 3 anymore. If you're an e-state user, you will automatically know that or see on July 1st that the new affidavit will be created automatically for any wills generated after that date. And so just be aware of that. And that's a nice thing to know. Note this as well, and I just spoke with somebody at the on the rules committee. For some reason, they got it wrong originally, then they corrected it to read deponent, and now they've put it back to say applicant. Now, it's of course not the applicant that's swearing the affidavit of execution. Well, it might be, I guess, but it's purely coincidental. It's the witness that's swearing this, and so they are going to have to change this back to deponent. It doesn't affect you if you're, if you know what you're doing, because you're not going to put in the applicant's name here. You're going to put in the witness's name. But I just want to point that out, that there's probably a mistake in another fix that's going to be coming down the pike. So that's what I've got for you today. I do want to point out that there's some great resources on Estatably's website. It's not rocket science by any stretch. And if you go, and we'll probably put a link in our slides to the website for the ministry, the forms themselves, you can just download them. They come in Word documents and just do that. And we will also, I guess, Michaela will also send everyone these compared versions if they want. They can do that. So that's what I had to say. I've got a few questions. And I'll see if I can address them. So first question is, please circulate the track change forms. I will. I dealt with that one. I dealt with 2 of the questions already. A hypothetical question. Let's say the testator drafted 2 wills. Primary will, the entire estate is less than 50,000, and the other is much more value. Should the testator just state the value of the estate according to the primary will? Yes. So in the application, let me just be clear that the application is dealing with assets relating to, in my view, it's relating to the will that's being submitted, and the probate tax being charged on the will being submitted. And I've done this talk and mentioned it many times that, what you're looking at to determine what the value is what assets are governed by the will you're submitting for probate. That's the question. And all of those have to be included. But that's what the form is dealing with. It's dealing with the assets that are, and I'll just try to call this up here, the assets that are governed by the will that you're submitting for probate. Let's see, next question. If they are separated and there is a domestic contract in place, should that be referenced? I don't think the form specifically deals with that. I haven't looked at it, to be honest with you. You can always attach additional material to the application in the form of a schedule. So if that's something that you believe is relevant in some way, then you can certainly, you're allowed to include additional material with any application for probate. So yeah, again, the form really never dealt with the value of the estate for that's being submitted for probate, but that is the common practice for sure, to include assets that are governed by the will that you're submitting for probate. I've got another question here. We have a small estate application due to be filed after July 1st. There are forms. I would say if you're filing an application after July 1st, you can't use the prior forms. So if you've got them all signed and ready to go, file them now, or else do new forms. And that would be my suggestion, to be on the safe side. And we finished early, so I hope that at least gave everyone a heads up that we've got new things coming down the pike, and we're excited for changes in our law. This isn't the most exciting one, but it is interesting that we're getting a lot of law reform, and I commend my colleagues at the OBA, at the working group, which consults with the ministry on forms and getting them fixed and corrected and making it easier for all of us. So, those people are unsung heroes. So we really should recognize those people who put in make tireless efforts and work for free to make it easier for all of us. So I thank them and commend them for their hard work, and thank all of you, and hope to see you again next week. Bye-bye.